Welcome, everyone. Thank you so much for being here. I'm Annalise. If you don't know me yet, I'm the founder and director of Shasta Scout, news for Shasta County, news as a public service to the people of Shasta County. We're so glad you're here. Whoever shows up to any event is exactly who's meant to be here, and I'm always excited to meet you. So if you haven't said hi yet or haven't met me yet, make sure you search me out and introduce yourself or just say hi again. We do have some Shasta Scout stickers created by our administrator, Naomi, on the table, free to take if you'd like them. We also have a one-page handout from the First Amendment Coalition. This is Thad from the First Amendment Coalition, and this one-page handout will kind of get you connected with some of those resources. They're a nonprofit just like us. And there are also note cards on the table, so feel free to grab a note card, write a question now, or if you have a question throughout the event, just hold up your note card, and Madison, this is Madison, will come and grab it from you. I do want to introduce our reporters in the room. Madison Holcomb is our newest reporter, doing fantastic work, especially some of her reporting on our ICE facilities here in Reading, as well as the coverage of Native community members when she first arrived last summer. This is Nevin Kalapali. He's been here for almost 2 years, also doing really fantastic work on all kinds of things, but most famously some of the things are the militia stories and a lot of his cultural work as well. Along with his accountability work for RPD and getting some policies changed there. So Nevin's work on RPD's use of mugshots and how his reporting led to a change in RPD's policies is up for a national award through the Institute of Nonprofit News and has received a lot of recognition. I think it shows the power of community journalism, to affect not just a few people, but the many, many hundreds and probably thousands of people arrested by RPD each year. So good work. Today, most of our event is going to be led by Thad, so I'll kind of get him started in a minute, but I also wanted to introduce some other folks who are here with American Community Media, again, which is a nonprofit that does statewide work. American Community Media is partnering with us, has been partnering with us on our stories about ICE, as well as our stories about community resilience. So some of our stories about the Lao Thai Cambodian New Year, the festivals, all the things that are going on in our diverse communities. Some of that is kind of just coming through the support financially and editorially of American Community Media. So Peter, why don't you come on up and just say hi for a minute.
It's great to be here in Reading. The drive from San Francisco, when you see Mount Shasta sort of emerge over the horizon, it takes your breath away. I'm here with Sandy Close, our executive director. American Community Media, we are a nonprofit. We are based in San Francisco. We've been around in various iterations for the better part of 50, 60 years. And for the last 30 years or so, a lot of our focus has been on supporting community and immigrant-serving media, the ethnic media sector. So for 30 years, we've advocated to make sure that communities, regardless of political persuasion or what have you, that they have access to information. That is the basic bare minimum, and that's been what we've been invested in for the last 30 years. About a year ago, we launched a project trying to connect with media in communities that you don't always see reflected in the large media headlines. And so that's how we connected with Annalise at Shasta Scout. And boy, the quality, the dedication, the reporting, I feel like it's been a real honor to work with the team here. I've learned a lot about Reading, about Shasta, and really appreciate the partnership.
Thank you so much. So a lot of our stories that we produce are, just so you kind of know a little bit about the business of news media, we produce one story a month that we determine, we choose. There are no strings, there are no editorial guidelines. We choose one story a month to focus on that uplifts cultural diversity or supports accountability related to immigration. And many of those stories are republished on American Community Media, which means Shasta Scout and Shasta Story gets out to a much larger audience. And their financial investment in that also helps us to tell those stories and hold that space for some of that longer reporting, which is really, really important. So thank you for being here, and thank you for your investment. And First Amendment Coalition has also been a very important connection for us at Shasta Scout over the last 4 years, as we've continued to report on issues related to public meetings, issues related to the Brown Act, the First Amendment in a variety of settings, as well as press freedom. So originally our connection with First Amendment Coalition was contacting FAC through the hotline that you all can contact too, and just saying, we have this question, this is happening in a public meeting, is this legal, right? So we were using them as a journalistic source. Over time, they also supported some issues. For example, when we were pushed out of press access by the ROV some time ago, they issued that legal demand on our behalf. And also, when we were trying to get some body camera footage that the city had been withholding from us, First Amendment Coalition also supported that. So, but I just want to say, like, they are just a community resource for everyone, not just for us, not just for news media, but for every single person who has a First Amendment question, a Brown Act question. So this is Thad. He's going to introduce himself. Take it away.
Hello. Can everybody hear me okay?
Yeah.
All right. I am Thad Gurinson. I'm, as Annalise said, with the First Amendment Coalition. We are a statewide, nonprofit, nonpartisan organization that exists to advocate for free speech, free press, and government transparency. So first, I just want to thank Annalise and the Scout staff for having us here today, and American Community Media. This is an awesome event. Before I joined FAC, I was a local reporter, and one of the things I often lamented is just kind of an apathy from the general public about government processes, and it wasn't uncommon for me to go to a government meeting and be one of the only members of the public there. That does not seem to be a problem that Shasta County has. So got a couple dozen of you here tonight just to talk about open meeting law. So I really appreciate y'all taking your time to be here. David Loy, our legal director, is here with us. He is the star of the show today. I'm going to set up some questions for him, but it's really his expertise that we're going to be leaning on. So David, can you hear me okay?
Loud and clear. I hope I'm coming through okay. And sorry I can't be with you all in person, but it's an honor to be present with you virtually.
Excellent. Thanks, David. Can you tell everyone just a little bit about your background and about what FAC does to advocate for open meetings?
So I'm an attorney. I've been in practice a little over 30 years. I've been with FAC for about 4 years. And for about the past 20, 25 years, all or a large part of my practice has been free speech and open government. So First Amendment cases, public records, open meetings, both in Washington State, where I lived before coming to California, and in California. And for the last 4 years, I've done nothing but that with the First Amendment Coalition. And so with respect to open meetings specifically, we, as I think was mentioned earlier, FAC runs a legal hotline in which we share legal background information about Brown Act, public records, and First Amendment. So I've certainly consulted with numerous people about Brown Act issues. My office has litigated Brown Act cases. We have a Brown Act case pending right now against the city of Fresno. So it's something that's near and dear to my heart, is free speech and government transparency.
Excellent, thank you. So I want to start, before we dive into the questions, just acknowledging that we are...
Is that on?
Is this on?
There you go.
Okay, sorry about that. I just want to start, before we dive into the questions, by acknowledging that, we're not having this meeting today or this conversation today in a vacuum. We realized there was a very contentious Board of Supervisors special meeting on Tuesday that kind of highlighted a lot of the questions that I think we hope to answer today, that we hope we can at least address and lend some clarity to, and certainly questions that were on some minds here prior to Tuesday's meeting, and certainly were brought to us when we started contemplating kind of where this conversation was going to go.
Closer?
The mic closer?
There you go.
Okay. Apologies. So with that said, I want to touch on a couple areas of the Brown Act. But to start, I just want to start with the noticing provisions. David, can you talk a little bit about what constitutes sufficient notice for agenda items? Are agencies required to provide supporting materials, both to the board or the council at making decisions and to the general public? Do these requirements differ for regular versus special versus emergency meetings?
Well, so I have to give you the short lawyer's answer, which is, it depends. So the short version is that for a regular meeting of a body covered by the Brown Act, which is a city council, county board of supervisors, school board, certain advisory committees, and so on. But since we're talking about your board of supervisors, I'll just say board for shorthand. The board has to, for a regular meeting of the board, an agenda has to be posted 72 hours in advance at least, and a place open to the public and also on the website if they have one. For special meetings, it's 24 hours in advance with notice to media as well. For emergency meetings, if feasible, it's 1 hour in advance to the media that have signed up for notice, but that's not a hard and fast rule. I want to emphasize emergency meetings are very much the exceptions. Natural disaster, massive strike, truly unforeseen out of the box events. Regular meetings are on a schedule, as established by the board. Special meetings, again, anytime on 24 hours notice. Was there some more I'm sorry if I missed some of the components of that question. Oh, supporting documents. This is interesting. It's actually quite common practice for agencies to provide a full agenda packet before the meeting, often online. They'll post the agenda with links to supporting documents. And that's common practice, and I think it's a best practice, but the Brown Act doesn't always require that by the letter of the law. An agenda only has to, the agenda has to be posted in advance, and typically nothing that's not on the agenda can be discussed at the meeting. There are exceptions for certain circumstances. The agenda only has to give fair notice of what the item is, typically 20 words or less, so the public has essentially a fair clue about what's going to be on the table for that particular item. Backup documents, staff reports, and so on are a good idea, but not always required by the letter of the law.
So for a meeting, let's say, where a board of supervisors was going to consider a censure of an elected official, and the agenda item would have to say that, but might not have to go into the description of why.
That's correct. The purpose of the agenda is to notify interested members of the public that this is going to be discussed if they want to show up and learn more and hear more and or give public comment on the issues on the agenda.
Excellent. There were also some disturbances at Tuesday's meeting. So I'm hoping you can talk, David, a little bit about what constitutes a disturbance or disruption at a public meeting.
Sure, and I assume by disturbance and disruption, I assume you mean something that warrants an intervention by the board chair or potentially even removing somebody. And it really has to rise to the level of a bona fide disruption that makes it infeasible to conduct the meeting. So, for example, someone refuses to cede the floor after their time limit on public comment is up. Members of the audience are talking so loudly that they make it difficult for others to hear, or they interrupt or talk over speakers who are at the podium to give public comment, or they talk over and disrupt the ability of the members of the board to speak and be heard. If you're outside, on the street doing a protest, you can be pretty much as loud as you want, subject to local noise ordinances and things. But inside the meeting room, it's a very different story. It's much more regulated. It's not a traditional public forum. It's a limited public forum where they can say you need to stay within your time limits. You need to not talk over other people. When it's your time at the podium within your time limit, you have the mic and you can say more or less what you want as long as it's on topic. But can't really talk over. Certainly can't threaten to cause harm. Bona fide true threat of harm. Mere silent gestures, sort of like sort of shaking your head silently, or giving hand gestures, thumbs up, thumbs down. As long as you're not interfering with the ability of other people to observe and participate, that's not necessarily a bona fide disruption sufficient to warrant some kind of corrective action.
What would you say about applause after certain speakers or boos, hisses after others?
I think it would depend if it became so prolonged that it really slowed down the meeting in a substantial way. But if for example, there's a little bit of applause or booing, in the time that takes one person to stand up and another person to sit down, that's not really slowing down the meeting or really interfering with the ability to conduct the meeting. My view is I don't think that would be sufficient disruption to warrant a warning or removing somebody. But there's not a lot of case law on this, so these standards are a little unclear at the margin.
Okay. And you mentioned warning. My understanding is the law requires that the chair of the board issue a warning prior to somebody being removed. Is that the case?
So yes, so there's two provisions at issue. There's a provision for clearing the entire room and continuing the meeting. There's also a provision for removing a particular individual. The provision for removing a particular individual says that the chair or their designee is responsible for identifying what's going on and giving a warning to the person with an opportunity for them to come into compliance before they can be removed. So for example, if somebody is at the podium giving their public comment and they go beyond their time limit, the chair or their designee is required to warn that person, hey, your time's up, please yield the floor and sit down or you could be removed. No warning is required before removing somebody for actually threatening to cause real harm to somebody.
Okay. And does the warning have to be given to a specific individual, or can the chair warn kind of the entirety of the gallery to pipe down and stay in order?
So there's a sort of sequence of events that has to happen, as I see it. In order to remove a particular individual, that particular individual must be warned. And that's what the statute, by the letter of the statute. There is a provision of the Brown Act which says that if order cannot be maintained or restored by removing specific individuals, then the body as a whole can vote. This requires a vote of the entire body, not just the chair, to have the room cleared and continue the meeting, allowing members of the press to remain. There's a little bit more nuance to that, but that's essentially the gist. Now, I want to pause on that for a second because sometimes what I understand happens is they don't clear the room and continue the meeting. Sometimes I'm told that your board or other boards will simply go into recess. That's a very different matter. The Brown Act doesn't govern that. And there's it's sort of inherent in Robert's Rules of Order or any the inherent powers of any body to take a recess during the meeting. And that's a sort of less dramatic step than clearing the room so that people aren't there to observe the board doing business. So there's no particular warnings or prerequisites if the board just simply wants to take a recess and let tempers cool down. We're going to take a chair, can call a recess, we'll be back in 5 minutes, 10 minutes, what have you. That's a very different matter.
Excellent. And in the event that the chair does order somebody removed, is there any appeal provision? Is there any way that the majority of the board could overturn that decision?
It's a good question. The Act says that it is within the discretion of the chair or their designee to have someone removed after a proper warning. I've never heard of a case where that's the majority's voted to override that. It's a good question. I mean, maybe theoretically possible, but I don't know.
Sounds like ultimately the chair has a ton of discretion in running the meeting.
With respect to removing one individual, now if we're talking about clearing the room entirely and continuing with the meeting with the press allowed to remain, that decision has to be made by the board as a whole, or at least a majority of the board. But if we're just talking about removing a specific individual, that authority is delegated in the Act to the presiding officer or their designee.
Can I interrupt? I wanted to
Yeah,
ask
please.
a follow-on with that. The difference between a recess and clearing the room, does that have to do with whether or not people are ordered to leave? So if the one person is removed, but can the rest of the public stay in the room unless there's an order to clear the room by a vote of the board majority?
So when the meeting's in recess, there's no meeting to observe. The Brown Act guarantees the right of the public to be present and observe the conduct of a meeting being defined as at least a majority of the board doing board business. If the meeting is in recess and no member of the board is there talking about, continuing with the business of the board, there's not necessarily a right to remain in that room because there's no meeting to be observed during that time. I'm not sure. Does that answer your question?
Sorry, I'm going to push into this one a little because this is something that happens a lot where we might have, there's what's termed a disruption. There's a decision to pause the meeting. They say we're going to call a recess and clear the room. But there is still a member of the public there who has decided not to leave. So does the rest of the public have to clear the room? Does the media have to clear the room? Who is allowed to stay in the room if there's still a member of the public in the room?
Right. So this is not really governed by the Brown Act because if the meeting's in recess, the meeting is not necessarily in session. There's no clear case law in this scenario. I would argue that there's a general First Amendment right to remain and observe, and I certainly don't want to. From my standpoint, I see no reason why the public should have to be removed. But I can't tell you there is clear binding legal precedent on this exact point because, as far as I know, it's never been litigated in a published decision. And it's not addressed by anything in the letter of the Brown Act because unless unless somehow the meeting as such in the Brown Act includes recesses during the meeting, I suppose one could make that argument that when the meeting's in recess, it's still ongoing and you still have a right to be present even though the board members are not discussing board business. This is kind of a gray area. It's not really clear in the Brown Act or the case law.
Okay.
It doesn't mean I think it's a bad idea to make people leave. Don't get me wrong. There's a gap sometimes between what is the letter of the law and what is best practice. Not everything wrong is illegal and not everything illegal is wrong. The first things I learned in law school. So we have to look, if you're talking about the letter of the law, that's very different from what I think is best practice or maximum transparency.
Excellent. Thank you, David. We're going to move on to a few questions about public comment, which has been a bit of a flashpoint at times here in Shasta. So first, who decides whether a commenter is off topic and by what criteria?
So let me back up and sort of set the stage for that. I apologize if this is known to everybody. In a regular meeting, the Brown Act guarantees the right to give two different kinds of public comment. There's general comment on any topic within the subject matter jurisdiction of the board. That's typically called non-agenda comment. People can give public comment on anything regardless of whether it's on the agenda or not, as long as it's within the sort of general subject matter jurisdiction of the board. And then there's the right to give comment on specific agenda items as they come up, or at least before the board votes on them. And so what is on topic or not on topic depends on whether you're giving non-agenda comment or agenda item specific comment. If you're in general public comment, non-agenda comment, it's anything that the board might somehow touch on at some point. Anything within the county's or the board's subject matter purview, construed broadly. If we're talking about comment on a specific agenda item, let's say there's 4 agenda items, and the board is considering item 1, you should be talking about item 1. If they haven't yet gotten to item 4, and the time to comment on item 4 is later, you have to wait until item 4 comes up to talk about item 4. So that's kind of what I mean by topic and on-topic. But who decides that? Typically, again, it's the presiding member of the board, whoever's presiding at that meeting, is the one charged with running that meeting, and has the discretion to, within the boundaries of the Brown Act, decide something is or is not on or off topic, and instruct the person potentially that they need to stop giving comment because they're outside the bounds of what's on topic. but the standard is, one, for general non-agenda comment, is it anything within the subject matter jurisdiction of the board, construed broadly, and for agenda comment, is it relevant to that specific agenda item?
So a scenario that I sometimes saw when I was reporting on these meetings is somebody would get up to comment on, let's say there's an agenda item that's a report from a government program. And they would get up and say, I really support this program, I like what you're doing here, and then pivot to talking about all of the programs in the county that they do not like, and spend the rest of their 2 minutes kind of decrying other things that they see as wasteful in relation to this one program that they do like that is the agenda item. Would you consider that on topic?
I mean, potentially, the backdrop for all this is that under the California Constitution, any law that guarantees the public's right of access, be it public records, open meetings, is supposed to be construed broadly in favor of transparency and narrowly in favor of lack of access or secrecy. So bottom line, when in doubt, err on the side of transparency and more access. So I'd say if someone's within their time limit and they were at least somehow talking about the agenda item, even if they were sort of talking about other things, it's arguably still relevant. If I say, I like your program here and I don't like all these other programs, that's still arguably relevant to what's on the agenda because the board has to make a decision. Do I approve this? Do I disapprove that? How do I allocate limited resources between different programs? So it's arguably still relevant. These are judgment calls that are often not litigated, to be honest. Public comment issues often aren't litigated because as a practical matter under the Brown Act and the case law, a decision of the board cannot be set aside as null and void due to a violation of public comment rules. Most Brown Act litigation is brought by people with a sort of a dog in the fight, so to speak, or they have money at stake and they want to set aside a zoning permit decision or a hiring or a firing, and they have money at stake, and so they litigate this. But you can't declare a board action null and void for public comment violations. There isn't a lot of litigation and a lot of published decisions on these kinds of public comment questions, at the margin. As a general matter, you have to stay on topic, whether for non-agenda or agenda-specific comment.
Okay. And I'm going to come back to the enforcement piece in just a moment, or the question of whether there is an enforcement piece. But what ability does a board or a board chair have to institute decorum rules? So rules of whether it's okay for somebody to curse during public comment, whether it's okay for somebody to accuse staff of malfeasance during public comment, things like that.
So this implicates both the Brown Act and the First Amendment. So under the Brown Act, and the First Amendment, local agencies, counties or otherwise, have the right to set so-called reasonable regulations for public comment. Things like time limits, things like being on topic, and so on. But the Brown Act expressly prohibits, as it should, any rule that prevents you from criticizing the board itself or criticizing the actions of the government. Case law under the First Amendment is crystal clear that the government, whether at public comment or otherwise, may not prohibit members of the public from criticizing public officials by name. And also, whatever one thinks of profanity as a matter of civility and decorum, the case law prohibits government from shutting people down just because it doesn't like what they say or how they say it. There's a famous First Amendment case from the Supreme Court in 1971, or thereabouts, called Cohen against California, and a person who was then a young man wore a jacket to court which said, and pardon my language, fuck the draft. And however rude one thinks that is, and whether one agrees or disagrees with that position, the Supreme Court held that he could not be punished for wearing a profane jacket to court. So by analogy, I don't think a person can be shut down or silenced for using profanity at a Board of Supervisors meeting. Just the mere act of using a profane word is protected by the First Amendment.
And what recourse is there if a member of the public feels like there's unequal enforcement of these rules? If some commenters are being silenced for being off topic or being admonished for being off topic, if some commenters are being admonished for decorum issues and others are not?
So yeah, the First Amendment and Brown Act certainly prohibited discrimination based on viewpoint. Unequal discriminatory application of the general rules that may be valid on their face. At the end of the day, I mean, short of calling that out and protesting it at the meeting itself or in the press or on social media, the ultimate recourse, if nothing else works, be it political accountability at the ballot box, and so on, the ultimate recourse is to take the agency to court and sue them in state or federal court for a pattern of practice, viewpoint discrimination. My office was involved in a somewhat similar issue in a case against Temecula Valley School Board, which settled. There was lots of issues in that case. One of them was, allegedly unequal application of the rules. There were other issues that the rules are just invalid in their face, and so on. But how do you prove that? It's like any other question of fact. You'd have to have a documented pattern that would, create direct or circumstantial evidence that the intent was to silence people based on their viewpoint.
Excellent. Now I want to ask you a little bit about what ability a board has to limit public comment on agenda items. And I want to couch this in that, as I understand it, the Shasta County Board of Supervisors has implemented or will implement a change to its public meeting policies beginning in July. And so as I understand it, the new system will allow 2 minutes per speaker and cap total comment for any agenda item at 20 minutes total. Additionally, a member of the public will be prohibited from commenting on more than 4 agenda items at a single meeting. In your opinion, do these rule changes conform with the Brown Act? Is this within an agency's ability to limit public comment for time constraints?
The Brown Act says that governing boards may adopt reasonable regulations of public comment, including but not limited to time limits on individual speakers or aggregate time limits for public comment. The Act does not micromanage how local agencies do that. There's not a lot of case law on this, but what little there is suggests that courts do give a lot of deference to agencies in what is a so-called reasonable regulation, assuming it's applied equally to everyone. So 2 minutes per speaker, 20 minutes per item. It's hard to say in a vacuum that a court would say that's absolutely unreasonable. When the law uses a word like reasonable, that tends to signal that agencies get a fair amount of deference. Even if you or I wouldn't, the judge wouldn't adopt a similar rule, they'll tend to defer to the agency, barring some extreme situation. So 20 minutes per agenda item, 2 minutes per speaker, does not sound to me like a strong argument that a court would strike that down. A speaker not talking about more than 4 items in a given meeting, I've never heard of that, but I'm not sure a court would say it's invalid. I think an agency could say that is designed to ensure more opportunities for more different people to speak and make sure that a few speakers aren't necessarily hogging all the time. I don't know if that's the case, and I'm just trying to think of what the argument could be. Obviously, one can construct counter arguments why it is unreasonable, and reasonable people could disagree whether that's a good restriction or not. But precisely when reasonable people could disagree is when a court is more likely to say the restriction is quote unquote reasonable under the law. Again, I can't guarantee that, but based on what I know about courts, what little case law there is out there about what is a reasonable restriction on public comment, I think that sort of gives you a flavor of how judges will approach those issues.
Okay. We are going to pivot here into some questions from the audience, and the first actually touches on public comment. So somebody wants to know, with public comment on the consent calendar, does a member of the public, of course a member of the public can request that an item be pulled from consent and discussed separately. Do they have any authority to effect that request, though? Or is that ultimately up to the board?
So that's a great question. So first of all, and I'll be a little bit tangential. If there's a consent agenda, members of the public do have the right to comment on any item that's on the consent agenda or the non-consent agenda. So you have a right to say, hey, I see you have this on your consent agenda. I think that's a good or a bad idea. Here's why. Even if the board does not discuss it, you have the right to comment on it. Now, as to whether something should be pulled from consent agenda and put on the regular agenda, the Brown Act has nothing to say about that, virtually nothing. There's only one section of the Brown Act that even touches on consent agendas, and it has to do with when the board makes an unconditional commitment not to repeat a previous violation after getting a cease and desist letter. But otherwise, the Brown Act does not micromanage what goes on a consent agenda and what does not. And I say this with full recognition that, consent agendas, while useful for some routine items, can very easily be abused. But as to, what can or cannot go on a consent agenda, or the procedures for designating it as such, are really up to the discretion of local bodies. And typically local bodies ought to have their own sort of clear rules and regulations about that. And it varies from board to board. Some agencies say it can go taken off consent at the request of one member of the board. Others takes majority vote or 2 votes or what have you. I'm not aware of anything that gives a member of the public the right to demand that something be taken off consent agenda. It doesn't mean you couldn't have such a rule. I think it's possible, but I'm not aware of any jurisdiction which has that.
Okay. Another.
I want to step back for a second. I mentioned a couple of things here about Brown Act remedies. I mentioned cure and correct and declaring null and void and cease and desist. I just want to I apologize, very, very quickly. Whenever someone claims the Brown Act has been violated, there's 2 different sets of remedies. Sometimes, if an item was voted on and wasn't properly agendized, you can potentially send a cure and correct letter. If they don't fix it, you can take the agency to court to have that decision revoked and declared null and void in some circumstances. But that's not the only remedy. There are other things, like I mentioned, public comment violations cannot be the subject of declaring an action null and void, but the Brown Act does have another set of remedies we call cease and desist, where it's like, I'm not asking you to declare a vote invalid, but you violate the Brown Act this way, don't do it in the future. And there's we have a lot of detail about that on our website. I can share more about that offline. If you want to write to us. I just want to be clear, there are different ways to enforce the Brown Act. I'm sorry, Thad, go ahead.
So a couple of people are pointing out from the audience that, and correct me if I get this wrong, I believe that our public comment and our consent calendar, like when people want to speak on the consent calendar, they have to wrap that into their 2-minute long public comment. And so they're saying if there's 14, 15 things on the consent calendar, what if they want to speak on 2 items? What if there are 3 items? And we have a lot of things in Shasta that end up on the consent calendar that might involve millions of dollars that are perhaps not what everyone would consider routine and non-controversial. So can you address that that feels like a limitation on the public speech. Am I capturing that correctly?
Yeah.
So I guess I have a clarifying question. Is there a separate time for public comment on the consent agenda versus time for comment on other agenda items?
They, in the last few years, combined the 2.
They're now combined.
So
Consent and non-agenda items.
I would need to know more about the facts. I mean, potentially, if you only have 2 minutes to comment potentially on 20 agenda items, consent or non-consent, I mean, that could conceivably be a problem. It might be so far as to be unreasonable. But I would need to look at that in more detail. But I'd say that definitely raises a problem. If say I'm at the meeting and there's a 10-item consent agenda and a 10-item regular agenda, and there's 20 items total, and I only get 2 minutes for everything, both consent and non-consent, and I don't get to comment specifically on each other agenda item as it comes up for regular discussion, I'd say that's a potential problem.
Okay. You spoke a little bit about violations and remedies. Somebody is suspicious that the board votes typically fall on certain lines in a 3-to-2 fashion, and is questioning how that might be possible without outside conversations. And they want to know, how would you go about proving that the Brown Act is being broken through serial meetings or meetings outside of what's scheduled in public?
That's a great question. I mean, it's like proving any other violation when you got to follow the trail of breadcrumbs. I mean, I defer to the seasoned investigative reporter in the room, Thad Greenson. but I welcome your thoughts on this. I mean, I would begin with a public records request to the county. I would want to know, because sometimes serial meetings will happen by text or email, or there might even be text or emails that talk about setting up a meeting. So I'd want a public records request for all texts, emails, communications, messages, etc., relating to this particular topic. I mean, you could wordsmith that as you like, but that's where I'd start. I mean, maybe you get a whistleblower, maybe you get a witness that sees the 3 board members in the in the back room of the bar. I don't know. I mean, it's challenging to prove a serial meeting, and by serial meeting, I think everybody knows it would be a meeting, of a majority of the board talking amongst themselves, either all in one place at one time or through a daisy chain of communications about board business outside of a regular notice meeting. That would be a Brown Act violation if you could prove it.
Well, yeah, I would second David's first step of just doing a Public Records Act request for correspondence. You would be amazed at what people put in writing.
Yeah, and for those who don't know, and I apologize for getting off topic here, speaking of topic and on topic, but there's no board chair here. That could rule me out of order if I am. Under the Public Records Act, this is, and I apologize if people know this already, messages exchanged on board members' personal email and text accounts are still public records if they relate to board business. Just to be clear. I apologize if that's obvious if people do that.
On the topic of public records, let's deviate here real quick. There were two reports that were hot items of discussion at Tuesday's board meeting. An investigative report by an outside law firm conducted into alleged misconduct by the Register of Voters, and then an internal investigative report conducted by county staff. During the board meeting, the board voted, the vote on this was not on the agenda, but the board voted to waive attorney-client privilege on the investigative report from the outside law firm. Somebody wants to know if that's legal for them to do.
Legal to do if it was not on the agenda, or legal to waive in general?
I'm curious about both. I think the question was phrased just in general, but I'd be curious about both.
Well, so to take the second one first, any client, public entity, private individual, private business, anybody that is the holder of a privilege is always free to waive it. The attorney-client privilege exists for the benefit of the client to help the client obtain, fully knowledgeable legal advice, and by giving the client the ability to have confidentiality with their lawyer. But that privilege exists for the client's benefit, and the client is free to waive it at any time. When the client is an entity, it has to be waived by the appropriate decision maker for the entity. In this case, that's the Board of Supervisors, and if a majority votes to waive, they can waive. Now, was it proper to do that at the same meeting if it was not expressly listed on the agenda? That's an interesting question. It could raise agenda notice issues. Arguably, it could be considered sort of within the scope of the central item. There are provisions of the Brown Act that do sometimes allow boards to take action on items not on the agenda. I don't know if those would be met in this instance. It's a good question.
And then the board and county staff said that I think within 10, 12 days, they expect both of these reports will be released to the public, subject to redactions. I'm just curious if you might kind of weigh in a little bit on what you think some reasonable redactions from investigative reports like this might be.
So let me step back a second and just set the stage. So if a document is legitimately subject to attorney-client privilege, it can be withheld in its entirety. I'm going to assume that this particular report of outside counsel did at least originally qualify for attorney-client privilege. That could be debated depending on the facts, but for the moment, I'll assume that to be true. The other report was just an internal report of, say, county HR or somebody within the county, not under cover of attorney-client privilege, looking into alleged wrongdoing by a senior official holding elective office, or any senior official in the county. That is and should be treated as subject to public disclosure under the California Public Records Act, because it was never subject to attorney-client privilege, and because it pertains to a high-ranking official, the public always has a compelling interest in the conduct of and investigations into the conduct of high-ranking officials. Now, with attorney-client privilege being waived and with the other internal report never being exempt from disclosure, in my opinion, in my view, could there still be parts of it that might be legitimately redacted? Potentially. I've had very, depending on the situation, if there are, the names of people who, I don't know all the facts. I understand it's allegations of harassment and, misconduct or what have you. Perhaps the alleged victims of that assault or harassment or misconduct, perhaps their names could be redacted, unless there's a compelling public interest in knowing who precisely was being allegedly harassed. Perhaps if there's, I don't know if there's sensitive medical details that might be included in the report, that perhaps the public does not have a compelling right to know. Things like that. I don't know if it has social security numbers, dates of birth, things like that. Probably not, but this whole idea of what is redactable for privacy really involves a balance between what's the public's interest in disclosure versus what's the privacy interest on a given piece of information.
Would you expect witness names to be redacted?
Potentially not. It depends. Often agencies do. On the theory that the person being harassed or allegedly harassed has a reasonable expectation of privacy and not having their name disclosed. On the other hand, circumstance, what is or is not a reasonable expectation of privacy is always inherently fact intensive, and it may be that person's already publicly known. I don't know. It's difficult to say.
One more question on these investigative reports. For the one that was done by county staff that you say no question should be considered a public document, is there an argument that document should have been circulated with the board agenda, should have been circulated to the public before the meeting?
As a best practice, I think so, but was it required by the letter of the Brown Act? It's not clear. I'm not sure that it is. This goes back to my earlier point that an agency is not always required to create supporting documents like staff reports or create them or attach them to the agenda or provide them in advance of a meeting, particularly a special meeting on 24 hours notice. Would it have been a best practice? I don't see any reason not to have done so. To be fully transparent, agencies are always free to be more transparent than the letter of the law requires, and I encourage that because transparency creates trust. But I'm not sure that it was literally required by the letter of the Brown Act. I think it should be disclosable on request under the Public Records Act, but the Public Records Act gives an agency 10 days to respond at a minimum, so they can sort of slow walk if they want to. I'm not saying this agency does or doesn't, but it's that leeway exists within the Public Records Act.
Can I ask a follow-on to that for our understanding, including mine? So for that investigation that was not necessarily under attorney-client privilege, the internal investigation by personnel, why would the board members have all been able to see documents related to that, but the public hasn't been able to? Like, is that a violation of the serial meeting law that they can all view these documents, but the public doesn't have access to them, or not? How does that work?
So it is not a violation of the serial meeting law if, let's say, for example, a copy of the report is emailed or given to each board member individually. Each board member reads that report individually, but they do not discuss it amongst each other. A serial meeting would only happen if a majority of the board discussed that report with each other, but outside of a notice meeting. But the Brown Act does not prohibit simply sending a copy of the same document to all of the board members, as long as the board members or a majority of the board members do not discuss it between themselves outside of a notice meeting.
Excellent.
That was actually a California Supreme Court case, that issue.
Okay. We talked earlier about public commenter decorum. We have a handful of questions here about board member decorum. Is there any recourse from the public if board members are rude, threatening, condescending?
So at the end of the day, the ultimate recourse is accountability at the ballot box. And the Brown Act does not create any particular rights to control the speech or conduct of board members. If and as I'm sure everyone knows, I mean, politics is politics. And it can get ugly, it can get nasty. And there's no First Amendment right, there's not to be offended or annoyed by the speech of others, elected officials or otherwise. And that cuts both ways. I mean, just as members of the public have the right to heap criticism upon board members, I mean, board members in theory have the free speech right to heap criticism upon others. Is that politically wise? Does that play well at the ballot box? That's a different question, but it's not necessarily illegal. If something rises to the level of going beyond just sort of, criticism and rhetoric to actual threats to take official action to retaliate against people, as in, I'll have you arrested, or I'll sue you, or, I'll have code enforcement, write you up, and that's unjustified. Yes, we can theoretically get into retaliation prohibited by the First Amendment. If we're talking about threats to take action against people, but just ordinary sort of rudeness and criticism and fair or unfair, right or wrong, justified or unjustified, it's, that mere speech alone is generally protected by the First Amendment, however annoying or rude it might be. And I'm not defending it, trust me, I'm not defending this as a best practice. If you're asking me as a First Amendment lawyer, what is speech protected by the First Amendment, regardless of its wisdom or its decency, the First Amendment does generally protect the right to be intemperate and rude.
If a complaint is lodged against a member of the Board of Supervisors and the county investigates this complaint, would the findings of that investigation need to be made public?
Depends how it's done. Sometimes these investigations are run through an attorney, and sometimes they can be kept confidential under attorney-client privilege if it was done for the purpose of assessing the facts relevant to potential exposure to litigation. But otherwise, if attorney-client privilege does not apply, and we're talking about an investigation into the conduct of an elected official or a very high official, like say the CEO or what do you call it, chief administrative officer of your county, or city manager, school district superintendent, that sort of thing, those documents are and ought to be subject to public disclosure, even if, in the case of a high-ranking or elected official, even if the investigation reveals that the allegation of misconduct is entirely unfounded. Because the public always has a compelling interest in knowing, was there a full, fair, and complete investigation into elected officials or high-ranking officials.
All right. Quick follow-up on that one. So when you say that they should be public record, does that mean that the public can have access to them, but only if somebody requested them? We would have to go fishing, for example, or have a source tell us those documents exist, or should they just be proactively released? Because that's a pretty big difference.
So, I mean, again, there's a difference between what I think is best practice and what the letter of the law requires. Best practice, absolutely, I think government should be proactively transparent as much as possible. But the letter of the law of the California Public Records Act obligates the government to disclose non-exempt public records on request of a member of the public. So there are a few things, but by and large, under the Public Records Act, the government is not obligated to spontaneously disclose records. It's obligated to disclose records on request. Exceptions here and there at the margin, but that's the basic.
And just because we got another question along these same lines, David, similarly, is there any obligation of a governing body to proactively make folks aware of the existence of an investigation? To announce that an investigation is underway into alleged misconduct?
Not that I know of under the Brown Act or Public Records Act, or First Amendment. I mean, there are, I'm not an employment law expert. I'm not a labor and employment lawyer. There may be obligations to inform, someone who made the complaint of misconduct, perhaps under employment law. I have no idea. That's just something way beyond my expertise. But in terms of announcing to the general public, I'm not aware of any obligation, legal obligation, letter of the law, to announce that, say, supervisor so-and-so is under investigation.
Okay.
Again, best practice, would it be great? Sure, I think government should be more transparent by and large, particularly about elected officials. Now, my premise here is that, it's one thing to say, an ordinary line employee, has, I think, arguably a greater expectation of privacy, but if one chooses to seek and hold elected office or a very high-ranking office, the trade-off to that is that one accepts a diminished expectation of privacy and a higher expectation of accountability in the public eye, and an even greater obligation of transparency as a general matter. My personal view.
One last question from the audience, then I'm going to ask you for just a final thought here, David. But someone wants to know, essentially, if there's anything allowing or prohibiting members of the board from communicating silently during a meeting with the county council. So this says through Teams, but I would imagine the same principle applies through text or email or any other communication silently.
It's a good question. I don't know that it's been decided by a court, but I would argue, if I had to litigate this, and I think I'd have a good argument, that if you're in an open and notice meeting, that everything that is being discussed about board business should be done openly and publicly. The entire purpose of the Brown Act is to empower the public to observe and monitor the operations of their government. So we don't have secret government at the local level. So the entire point is that deliberations of the board during an open meeting should be conducted out in the open. And so if there are side discussions going on between board members or between board members and staff during an open meeting that the public cannot see or hear, I believe that is or should be a violation of the Brown Act. I don't know that's ever been litigated, and it'd be difficult to prove, although again, you could make a public records request for any text messages and so on. But I think that's a real problem, because the whole point is that deliberations of the board during an open meeting, must be open and public.
I have a question. You talked about they can't talk outside of the meeting about agenda items. What if one supervisor sends an email to another supervisor and they talk about it? Is that okay? Outside of the meeting?
If it's less than a majority of the board in a given conversation, then it is not a Brown Act violation. So if you have a 5-member board and 2 members are talking amongst themselves, that's not a Brown Act violation, with a potential exception. If those 2 members of the board were members of a standing committee, let's say the board had a 2-member standing committee on public safety or planning and zoning and land use, and those 2 members were then with their standing committee hats on, talking about the business of that standing committee outside of a meeting of that standing committee, that's a problem. But if we're not talking about a committee of the board, but like we're just talking about a general board, taking the board as a whole, 5-member board, if only 2 members are having a side conversation outside of a notice meeting, that's not a Brown Act violation because it's not a majority of the board.
What if one person talks to another, one supervisor talks to another supervisor, and then the other supervisor talks to another supervisor, you end up with 3?
Yes, if it loops in 3 people, directly or indirectly, 3 members of a 5-member board, that's what we call a serial meeting, the daisy chain, if you will. A talks to B, B talks to C, A says to C, this is what B said to me. Suddenly you've got 3 members looped in, and there's an interchange directly or indirectly between a majority of the board. That's what we call a serial meeting. It could be by text, by telephone, carrier pigeon, what have you. If it loops in a majority of the board that is interacting with each other, in person, in real time, or over time, that is the kind of serial meeting that Dad was talking about earlier, right? Then you get to how do you prove that? We talked about, get the copies of public records and testimony and so on.
Excellent. I see that we have a few more questions. I think we have a hard out on time though, Annalise, is that correct?
So we have the room until 6:30, but I don't know about having David, access to David.
Do you have a few more
I'm
minutes,
happy.
David?
I'm available and happy to keep chatting if others are interested.
Okay, let's take a few more.
I have a quick question about the one of the investigations of our county clerk. Do victims, does the person that made the allegations and the witnesses that were part of the investigation, do they have any right about having their names redacted when the files are finally released to the public?
Potentially, again, that depends on whether they have a recognized or reasonable expectation of privacy. They may. I would need to know more about the facts. It's possible, I'm not sure.
In the back?
Yeah, if two supervisors are having a conversation, sidebar conversation next to each other, and it's a habitual thing that happens every 10, 15 minutes, whatever, and, one is whispering to the other, not like, can we take a bathroom break? I mean, they're like talking about stuff. And is there any, apart from being unethical, is there any, anything that would be illegal in that?
Yeah, I don't know if you caught that, David?
Yeah, Ted, could you summarize that for me? I'm sorry I followed that. I'm sorry.
Yeah, so he's asking if members of the board during a meeting are visibly communicating with each other, having kind of sidebar conversations. Is there anything that, is that out of bounds, either ethically or legally?
Or one is directing another, not the chairman?
Or if it
So,
appears one is directing another, you say?
So as I said earlier, if the board is holding an open public meeting, all of its discussions and deliberations about the subject matter of the meeting should be open and available to the public. Now, if they're having a side chat about, where to go for dinner after the meeting, no harm, no foul, because it's not relevant, or a side chat about somebody's birthday party, that's a different matter. But yes, if you've got, again, this has not been litigated to my knowledge, but the whole premise of the Brown Act is that all discussions, deliberations of members of the board in an open meeting should be open and visible and audible to the public. That's the whole point, to give the public the right to observe and monitor, how the board is doing the public's business. So if it's a side chat, whether it's a majority or just a minority, board members, that's about the business before the board, then I think that's a Brown Act problem.
Okay, one more here.
Yeah, I'm going to circle back to Susan's question, because I was on the board with these, I was a supervisor for 8 years, and I would visibly witness before every board meeting, I would see Supervisor Cry in talking to Supervisor Kellstrom prior to the meeting. 5 minutes later, I might go to the coffee machine and walk by, and Supervisor Cry went into Supervisor Jones's office. They did this every single meeting. The three of them would communicate prior to the meeting. I would assume that would be considered a serial meeting.
Well, to prove that's a serial meeting, you'd have to know exactly what they were talking about. It's certainly a circumstantial evidence that raises concerns, but you'd have to prove exactly what they discussed. To actually prove a violation of the Brown Act would require evidence as to what they actually said. But you're right, it does raise, it's a circumstantial red flag.
Excellent. Well, I was hoping you could conclude, David, by talking a little bit about what you wish members of the public knew about the Brown Act. You field tons of legal hotline inquiries about the Brown Act. You talk to reporters about the Brown Act. You've been dealing with this for decades. What are a couple basic principles you wish kind of everybody knew walking into a public meeting?
So there's a large gap between what the Brown Act actually says and what a lot of people think it means, or what the best practice might be. And this is in no way, shape, or form to discourage people from advocating for more transparency than the Brown Act, that the letter of the Brown Act requires. But it's important, and this is why we have a legal hotline and resources available. It's very important to track down on any given Brown Act issue, what does the letter of the Act require before launching into a lawsuit or advocacy that says this body has violated the Act versus, well, maybe they're in compliance with the letter of the law, but they should do it differently, here's why. And the other thing I would say is, no, don't be bound by the letter of the Brown Act. It's perfectly within the board's power, or any board's power, to adopt its own rules and regulations that go beyond the minimum required by the Act. So if you want better access to backup documents or agenda packets or staff reports, you're free to advocate and seek a local rule which mandates that for your board, right? The board is absolutely free to go beyond the floor established by the Act. The Act is a floor, not a ceiling on transparency. So I encourage people to think creatively about opportunities for local advocacy for local rules and regulations to create more transparency, more access than perhaps the letter of the Brown Act requires.
Excellent. Thank you so much, David. Annalise, do you want to say a few final words?
Yeah. I just want to share, one of the reasons that we hosted this event is that we really want the public in Shasta, from every part of the political spectrum, to recognize that there is a resource here. It's a nonprofit resource. Anyone, we have handouts here, anyone can go on their site and submit, like right there on the site, a quick request, a hotline request. I have a question, this happened in a board meeting, what should I do, right? Or what are my rights under the law? So it's a really, really excellent resource that you don't necessarily have to go through a journalist to get. You don't have to wait for someone to come see you to get it. And I also really want to emphasize that, you know, especially over the last few years, I've spoken to both Thad and David many, many, many times. And I have learned a lot about the law, and the law is a very beautiful structure. It's like this backbone that provides our society with something to fall back on, to the structure of society. And one of the things I really appreciate about David is when I call him, he will not take a political side. He doesn't care if, you know, somebody that most people would like or somebody most people wouldn't like did something. It's not about the person, it's about what the law says. And so I really want to emphasize that this is not intended to be partisan in any way. It's not intended to be one side of the board versus the other side of the board, one side of the public versus the other side of the public. We all have to be willing to come back to what the law says and abide by that law, or we work through proper channels to change it. So yeah, I just hope you'll take advantage of this as a resource, and I hope you'll remember, you know, First Amendment attorneys, they are incredibly focused on First Amendment rights, whether they support things they personally agree with or things they disagree with. And we all kind of have to be in that same position of supporting the First Amendment regardless of viewpoint.
Yeah, just to add to that, I would just say, yeah, and please use us as a resource at FAC. We exist to help people navigate these issues. They are often complex, as David often says, they're often fact-specific, but please don't hesitate to reach out to us. We have an informational sheet out on the table that has links to some of our resources. Please use those. We are here to help you navigate these issues.
And if you still have questions, that's here.
Yeah, David has to go because he's on Zoom, but I will be here and happy to answer any questions I can. Thank you, David.
Thank you all very much, and thank you for showing up and caring about these issues. It's we the people doing the work out there. I can't thank you enough. Bye-bye, everybody.
Thanks, David.